And the other part that I tell people often is focus on what is the legal issue. Contends no torturous conduct could have occurred because no duty had been placed on him. They're going to break that down in this case as well. Forget the other part about him not being in the state. But what this case is going to do is show people, is give you all at least hopefully a underlining understanding. Until you have an obligation, you don't have an obligation. When we get in there, a lot of times we talk about everything except what was my obligation, to what rights would you have as you were there. Because if you're a father, depending on what state you're in, like in Florida, mothers and fathers have equal access to the child. Did you raise any of these issues? Was it a purely an administrative issue? Or like my cases were judicial. That's why the procedural aspect of it matters. If your case is administrative, did the administrative process that your state used violate a well-established protection? If so, how do you go about reversing that issue? It's the questions that we ask that are directly related to the order, ORDER. What does your order say? How did they get the order? Was
You
it
know,
by
it's
default?
it's funny you brought that up when you talked about my case the other day, and we went through all these things. And I'll be honest with you, everything you're saying is true. Everything you're saying is like sound like it's
Not
the
just
same thing I went through.
reading what the court. I'm just going with what the court said. Look right here. Read that part right there for me. The green part. Fact. LK, read if you can read the that orange, and then Ralph, you read the green. Ken, read the orange.
All right. Wright contends that no torsions conduct could have uh, occurred because on duty had yet been placed on him. He argues that until paternity is adjudicated in the court, he is under no duty to pay child support, and this committed no tort.
Yeah, you must be on the
Then
phone. See
then you
that?
got
Yeah.
we agreed to saddle a defendant with the burden of child support before paternity, and as established would be both illogical and unjust.
See that? To saddle a defendant with the burden of child support before paternity has been established would be both illogical and unjust.
Mm, 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 mm.
A court cannot, as an initial matter, assume that a defendant is the father of a child so they can adjudicate the matter of non-support, and upon finding non-support, use such tortious conduct as the basis of jurisdiction to adjudicate paternity. That's not Greg. That's the case law. But what they're telling you is, think about this. And then they come back and say, well, they find this to be persuasive. So this must have come out of the Florida Supreme Court. See something. Yep, Florida Supreme Court. So the Florida Supreme Court was trying to settle a conflict between two different DCAs because they said we find it persuasive, meaning not binding. Several states, and this is always important, persuasive law means they can consider it. Binding means they must follow it. Y'all get that?
Right.
I think you might have seen that also when it came to that Holmgren case somewhere, persuasive versus binding. But anyway, several states have analyzed this type of situation under similar long-arm statutes, have reached the same conclusion. And they give you states. These courts reason that failure to provide child support is only an ancillary issue in the paternity proceeding, with the primary issue being paternity itself. As did the second district, we accept this reason.
Wow, that is crazy. So
So
imagine these cases have been brought before the Florida Supreme Court, and yet they still operate under apparatus agenda, changing and adding what they want outside the guidelines of child support. What is that? I'm telling you.
maybe we got to go back to what we did about not in the show before when we talked about affirmative defenses. When you walk in there, if you don't raise the affirmative defense that, hey, I don't have a responsibility yet, we get in there to talk about everything else. But
Yeah.
hey, wait a minute, whoa, partner. You haven't determined meritoriously that I'm obligated to do shit.